Before we get going, though, I wanted to let you know that we are working on having our last class be in person. I've contacted the Red Cross in Akron, and I haven't gotten the final confirmation, but I got a tentative confirmation that they will have space for us. So I will keep you posted where our last class will be, but it'll be at the same time and on the same day. It'll be that Wednesday, November 16th. From 6 to 7:30. So I'll keep you all posted. I just wanted to give you a heads up that that last class will hopefully be in person so everyone can meet each other and we can have a nice celebration at the end. So we are at 6 o'clock. I know a lot of people tend to log on at, a little bit after 6, but we are going to get started because we have some great speakers today. I wanted to introduce our first speaker. He is the chief of our criminal division. It is Brian LaPrenzie. I saw him logged on here. Yep, I see him. There we go. All right, so I'm just going to turn this over to Brian.
Hi, everybody. As Tanya said, my name is Brian LaPrenzie. I'm the chief of the criminal division, and I have been working in the prosecutor's office now for, on and off for about 25 years. So I'm glad to be here with you tonight. We're going to talk about a kind of a heavy topic, but it's really more for the purpose of explaining to you guys the whole process of the death penalty, when it can be imposed and how, and kind of clarify maybe some misconceptions that are out there. So bear with me for a minute. I'm going to try and share the screen here while I pull up my presentation.
While you're doing that, I just want to remind everybody that we will have questions at the end so Brian can get through the presentation. So before Brian logs off, we will have time for questions and make time for you. And James and I will be checking the chat, Brian, with questions and make sure to get those to you at the end.
Okay, so did I hit the wrong button there? You might.
No, you hit the right button. You got it.
I did?
Yeah, way to go.
Yep, I can see your presentation. Are you okay with it too, Brian?
No, mine doesn't show it. That's kind of interesting. Okay, well, I think I have it now. So just so you guys can see just the big death penalty process screen, and that's all you see?
Correct.
Yep.
Okay. Okay, very good. I just want to make sure that I'm looking at the same thing you guys are. All right. Okay, so we'll get started here then. Like they said, so I have about 26 slides that I'm going to show you. There's lots of words. So don't try and necessarily read all the words. I'm going to kind of review them. If you start reading them, you'll get lost in it, but it's just information that I want to put out there. And then we'll talk about it. If you do have a question because you're confused about something, you feel like if you don't ask now, you're going to be lost. That's fine. Go ahead and maybe interrupt. And that's fine. I don't mind that. But for the big overall picture questions or, things that can wait, we'll wait at the end and we'll try and do that at the end. I am not used to doing stuff by Zoom, presentations by Zoom. So this is really weird for me. I usually walk around and use my hands a lot and stuff. And so this is kind of a little bit awkward for me. So bear with me while I try and do this. All right. So first of all, just a quick overview. This is what we're going to talk about. First of all, death is different. And we'll talk about why and where that comes from. The second area we talk about is then we're going to cover the law. What is the actual law in the state of Ohio for imposing a death sentence? And then lastly, the topic we want to talk about is not only is there the law, but as the prosecutor, Sherry Bevan Walsh has discretion in prosecution. And so therefore, we have a process in place in which we then decide, although legally the death penalty may apply, whether we're going to use our discretion and not apply it, even though the law says we could. So those are the three topics we're going to talk about tonight. So the first topic is, death is different. So,
Hey, Brian.
Yes.
Sorry to interrupt, but I just want to make sure.
Oh, wait a minute.
Advance your screen.
Yeah, my screen. see, it's not advancing on the one you guys have. So
There it goes.
those are our three topics.
Thanks.
All right, so I had it on the wrong screen. Okay, so this is we were talking about death is different. So basically the United States Supreme Court, 100 years ago, 90 years ago, dealt with the death penalty. And as you obviously know, death sentences have come a long way from hundreds of years ago. If you caught a horse thief, in the act of stealing a horse, you could literally hang that person without a trial, without anything. And that was acceptable hundreds of years ago. Obviously, we've come a long way from that. And so the Supreme Court has been ruling on death penalty cases ever since this country's been in existence. And this is just one of the things that the court has said that's kind of been, used a lot in my, in the law field. And we quote it often. And this is where they tell you that we must consider, I'm just going to read this for you. We must consider whether the punishment of death is disproportionate in relation to the crime for which it is imposed. There is no question that death as a punishment is unique in its severity and irrevocability. I can't even say the word. So as you can tell, as we progress, this was from, decades ago, this case. Well, years ago, when we talk about the fact that, you could have the death sentence for things that were not murder. And so, they're clearly saying here that it's got to be proportionate. And so now, as you probably know, in the state of Ohio, the only way to get a death sentence is on a murder type charge. In regards to then, of course, it's different. They highlighted that when they told us the defendant's life is at stake. The court has been particularly sensitive to ensure that every safeguard is observed. Now, when they say that every safeguard is observed, you've all probably heard of due process. Due process is a word we've all probably heard of, but most of us don't really always understand what that word means. So some may not. So due process is that thing where we have a legal system in place with a process for attaining certain results. So if you have a dispute with your neighbor and you say they took your lawn tractor and they say I didn't, you can't just go get the lawn tractor. There's a process, and it's called due process. We go and we take that person to court, we file lawsuits, and we do the whole process. In a criminal setting, it's even more because we're taking somebody's freedom away. So you can't just go grab them up, throw them in jail and say, hey, I saw you do this, and therefore you're going to go to jail. So we have due process. When you have a death penalty, that due process is painstakingly followed. And so that is one of the precautions that they take, and they want the Supreme Court of the United States has basically said you must follow this due process and you must do it absolutely and be particularly sensitive to it. So let me see here. Okay. So what does that mean? I just kind of talked about that a little bit. Courts take those safeguards when dealing with due process issues. So one of the extra steps that we have in a death penalty, if it's a death penalty case, is that you can't just have the crime of murder. You have to have extra or special findings in order for it to even qualify for a death sentence. So you can't just say, oh, this is a murder case, therefore he's going to get the death penalty. It's kind of interesting to me when we have a grand jury, and I think you've already had, Tanya, you can tell me, they've already had grand jury topic?
Yes.
So in the grand jury, you understand how they bring it in and to the grand jury, and that's our first step of getting it to a trial stage. And the grand jurors, when we come in and say you're going to hear your first murder today, they all want to know, is this going to be a death penalty case? Because they think all murders are death penalty eligible, and they're not. So basically, you not only have to have the murder, but you have to have a special circumstance, and we'll talk about those more detail later. And then finally, one of the extra steps in a death penalty case is that most every death penalty case, the citizens, the community ultimately has the last word on whether death is going to be imposed or not. So it's not some judge or some lawyer or prosecutor. It's going to be the community that ultimately has the say in whether the death is imposed or not. Okay. So as you've probably already talked about, we have a trial. You see it on TV, everybody watches Law and Order and all the different shows. And that's ultimately what most people's understanding of the criminal process is that you have a trial. Well, not only do we have protections during that trial, we have rules of evidence that we have to follow and rules of procedure that we all follow during that trial. There's also safeguards that are put into place prior to that trial for not only the death penalty cases, but every cases. But because the death penalty cases are more serious, people are more stringent about following these things. So the procedural safeguard that is in place is that we have, in a situation where you have a murder or a crime that might be eligible, you have the police investigation. The police investigate the crime. They look to see if they can determine who it was that committed that crime, that heinous crime. And they themselves look to figure out who did it. And they have their own process. They have their own process of elimination to figure out who did it. They use scientific techniques now. We know about DNA. We know about fingerprints. We know about videos, cameras. We know about video evidence, which is actually becoming probably more important to us than DNA. Interestingly enough, I heard a statistic years ago about how many times somebody in England is captured on video camera, on a daily basis. And there was some number like, 100, 150 times a day. In the United States, it was like 10. Now, I would bet in the United States, you are probably captured on video camera probably 100 times a day, minimum, because every time you walk into a store, every time you drive down the street, we're capturing you by Ring cameras, everything. So it's become huge. So that's the stuff that the police department, they verify themselves. Hey, do we have the right guy or not? Once they have decided themselves, hey, we have the right guy, we have the guy that committed this offense, they then bring it to the prosecutor. The prosecutor then reviews that case and they look at it, and we look at it, our office looks at it. And actually, I take it back. Usually in Summit County, you have a local prosecutor. So not just the Summit County prosecutor's office, but if Akron Police Department arrests a guy and they say, we've got a guy, they will review it with their prosecutor's office, their legal advisor, and say, hey, we think we have enough here to submit this to the county prosecutor's office. And their prosecutor will review it and say, yes, I think you have enough. Go ahead and submit it. We then get it and we will take a look at it before we even present it to grand jury. We'll look at it and go, hey, before we even present this to grand jury, do we think there's enough in a good faith belief that we're going to get this case indicted, but not only indicted, but that there's a likelihood of conviction at the other end. So we then review it. After we review it, the next safeguard in place is that the grand jury is going to review it. We're going to present that evidence to the grand jury and say, hey, listen, this is what the police found, and here's what we think the charges are. You tell us what you think, and they vote. Now, as you already know from that, it only has to be 2/3 of a vote to get it passed. And that just gets it to the next stage. In a death penalty case, prior to going to trial, and prior to even adding the death specification, there's a prosecutorial review that we have now instituted in our office with aid from the defense attorney. That's very unusual. In the past, the prosecutor's office would get the case from the law enforcement officers. We would either present to grand jury, and we would decide ourselves whether a death specification or death sentence should be added to the case. That's not the case any longer. We have used our discretion. We've decided to invite the defense attorneys to be involved in this process. The last thing that's a due process protection or safeguard before he even gets to trial is that there are legal rulings that can be had. Defense attorneys will file motions to have certain aspects of a case suppressed or dismissed, the defendant's statements, evidence we may find. They may challenge a search warrant. all kinds of different legal avenues that they can pursue prior to even getting to trial. And if the court agrees with them, they can exclude that evidence, and that exclusion of the evidence could prevent us from then proceeding on a death penalty. Okay. Oops. Okay. Once we get past all the safeguards we just talked about, we'll have the trial. And assuming during that trial, of course, there's safeguards during the trial, like I told you, like we talked about. You have the procedural safeguards during the trial. You have the rules of evidence that we must follow, and the court oversees all that. If then at that time, after the trial, there's a conviction, even though that conviction is in place and a death sentence is imposed, you then have safeguards after that because they have a right to appeal. So once they have the jury decides a verdict, first level of review is going to be the court that tried the case. They're going to review that, and they can review it at the defense's request. And basically the defense says, hey, look, we know that the jury decided that he deserves to be convicted, and there's the sentence. However, we feel that that jury lost its way and they were misguided somewhere along the way, and there's no way possible that these jurors should have found him guilty. The court then has to, based on its own listening and hearing and watching and observing all the evidence in the trial, they then will say, no, I believe that there was definitely enough evidence to support the conviction that they found, and deny the motion. Or they can say, I agree with you. I listened to the same trial they did. I do not know how they came up with this verdict. And I feel that they lost their way and somehow got, down the garden path that they shouldn't have been. And I find that he is not guilty, and that's case over. Okay. At that point in time, it's over. And double jeopardy would come into place. We could not retry that unless we appealed it ourselves and then had it reversed. After the court, if the court were to say, hey, no, I find that the jury did not lose its way, then on a death penalty case, it goes right to the Supreme Court of Ohio, and they will review the case, and they will determine whether any procedural protections were violated. They will review the evidence. They will review all aspects of this case. And they will determine whether there was any reason for it to be overturned or dismissed outright. If they agree and say, nope, the conviction should stand, then at that point, those are criminal reviews. There's also a process in place on the civil aspect. So the defendant could then civilly sue the state and basically say, hey, I understand criminally I was convicted. I lost all my criminal appeals, but I have a civil right to protections, and I'm going to sue civilly. We go through the same process. It's called post-conviction relief. And that post-conviction relief suit is then taken to the courts again, the trial court again, and they have a whole process and hearing for that. If they're not successful there, they can appeal that. And if that's not successful on that appeal to the appellate court, they can appeal again to the Ohio Supreme Court. So as you can see, if you're convicted of a death sentence, you have lots of state appeals to go through before that sentence would ever be imposed. If all those appeals are exhausted, it's still not over, because once you exhaust all your state appeals, then you jump over to the federal court, the United States federal court system, and they can then file in federal court. You've heard the words habeas corpus, and that's where they file their habeas corpus actions, and they start in the U.S. District Court. And if they lose there, they appeal to the appellate court in the U.S. District. And if they lose there, it goes to the United States Supreme Court. If they lose in the United States Supreme Court, it's still not over. And the defense can keep repeating this process anytime that they feel that they've got new evidence or discover something that they could not have done or brought up previously. And that's why sometimes you hear about these cases where people are on death row for 15 years or more, is because there are so many steps and processes in place to protect their rights, to ensure that there isn't a mistake made, that it does take time. I think the average in the state of Ohio, I haven't checked it in a little while, but the last I checked, it was probably about 15 years that a person's on death row before a death sentence would be imposed, or actually carried out. And I know there's some that are longer, some that are a little shorter, but that's kind of typically the amount of time. Okay. One of the other things that people kind of tend to forget, and if you think about it, is that during the legal processes, they also have the ability through a non-legal means to try and get the death penalty removed from the case. So during the process in courts, the defendant will have lawyers that are appointed to him if he can't afford them. And that defense team will be working on trying to advocate outside the courtroom for their release. You see that all the time, where you see, like, I think Kim Kardashian has done a couple of these cases where she's gotten on board and tried to help their defense team to get public outcry and, you know, have somebody move to do something about the case. Nonprofit organizations such as the Innocence Project will work to try and get the death sentence removed or the case completely overturned, and anywhere in between. Family members will get involved also with trying to have that done, and also citizens. We talked about Kim Kardashian's a famous person, but also just normal citizens, everyday citizens that maybe have a reason they believe that this person should not be convicted or sentenced to death. And sometimes it's not always about the conviction. There are a lot of people that believe that although he was convicted, he or she don't deserve to be put to death. So they advocate outside the courtroom. That advocating is typically to or for clemency. So in the state of Ohio, if you're convicted of a sentence of a murder and sentenced to death, the governor has absolute power. And that governor can come in without any hearing. He can do it on his own. And they can do three things: pardon, commute, or reprieve. They kind of all have similar things, and I'm not even so sure that I understand myself the exact distinctions. But a pardon means, look, I forgive you. This didn't happen. It goes away, and they go home, and no conviction even exists. It was like they never got convicted. Commutation is the governor could do basically anything they want. They can say, look, the conviction stands, but the sentence is no longer death. It's going to be life without parole. They could say, the sentence stands, but I'm going to commute the sentence and you can go free. You've served enough time, depending on how long they've served. So they can do kind of any variation they want of the sentence or of the conviction. And reprieve is a combination of those. They can pardon parts of the case and commute some of the others. So those are the things that are outside the legal process that is going on during the whole time the person's on death row. All right. Then last but not least, we in our office have a conviction review unit that started a few years ago. Basically I think it was prior probably to 2019, or maybe in 2019, we came up with it was finally finalized in 2019. And basically this is our office, our internal review. So obviously there are cases that are 20 years old, 30 years old, that a person's been convicted. And it's not just death penalty cases. It could be any kind of case. It could be just a sentence of life without parole, or life with parole eligibility after 30 years. And if that person's been sitting in prison and they believe that they are not guilty of these crimes, then they can apply to our office. Now, obviously, times have changed, right? We have DNA now that we didn't used to have. And there's all kinds of statutory provisions for retesting for DNA, but there's also the ability for them to do this. And once they've exhausted all their appeals, they can then appeal to us and say, hey, listen, I was convicted by your office 20 years ago, and I believe that I was not properly convicted. I feel like there was some, first of all, I was either innocent or I did not get a fair trial because of some a violation of my due process rights, okay? And our office will take a look and see, hey, look, 30 years ago, they did not turn over certain information that was exculpatory to the defendant. Something that was in, and I think you've talked probably about exculpatory evidence, which is basically things that tend to show the defendant's innocence, okay? And so if we find things like that, we can review them and go, hey, listen, we think that there was a miscue here. And so basically that's another option for the defense or the defendants to try and change or alter their sentence or their conviction, okay? All right. So let's just talk a little bit about the law. And I'll ask you, I don't know if in the chat if there's any questions at this point, but I'm going to just ask you guys if there's anything at this point before we kind of talk about the law, about what we've talked about so far. I think it's kind of, those are kind of a big brush pictures of the whole concept of how the protections are in place. Now we'll talk a little bit more about the specifics of how the death penalty is actually, how we get to a death sentence. So, yeah.
You did touch, there was one question in the chat and you did touch on it, but maybe just a little more explanation was asked by Rachel. She said, how does the community weigh in on this?
Okay, so yeah, we will touch on that. And maybe while I start the next section, if Rachel could just clarify when she says, how does the community weigh in on this? We're going to talk about the jurors' input into this. But if she's talking about in general, the community as a whole and the community's view on the death penalty, then just clarify that so I know exactly what you're questioning or asking about. Okay. So in order to get a death sentence, you have to qualify legally. So the question is, what's enough? What kind of crime is enough to even qualify for a potential death sentence? Because remember, just because the law says this case is death worthy, okay, that if you commit this crime, you are worthy of death. That only makes you eligible for death. It does not mean it's an automatic sentence. So basically, you have to commit a crime of a homicide. So you must cause the death of another person, and it has to be with purpose or intent. Okay, it can't be an accident. You don't have, car accidents that end up in death sentence. It has to be intent. In other words, I intend to kill you. All right. It's not I shoot in the air on 4th of July and the bullet comes down 2 miles away and hits somebody in the head. That's not intent. Okay. Those are reckless. They're either accidental, but they're not purposeful killings. So you have to purposely kill somebody. I mean to kill them. You have to do it with either two things: prior calculation and design, okay, which most people know from TV as premeditated murder. You have to premeditate the murder. It can't be something that happens at the spur of the moment, heat of passion, you're in an argument and it goes awry and somebody gets killed. It has to be premeditated, okay? If it's not premeditated, then we have other types of ways to do it, which is during the commission. If you commit the murder, now it still has to be purposeful. You have to mean to do it. But if you purposely kill another during the commission of another offense that's enumerated by statutes, listed in the statutes, then it also qualifies you for potential death sentence. And those are the bad ones: rape, kidnapping, robbery. Those are the high level offenses that are felony offenses. They're highest level felony offenses. And if you commit a murder while committing one of those other offenses, then that qualifies you also to be eligible for a death sentence. But if you have those crimes, if you commit a purposeful murder, you do it with premeditation, or during one of those other offenses, that's still not enough. Then we have to attach to that charge a specification. We call it a death spec. And that death spec means that not only did you do it with premeditation or during the commission of one of these offenses, it also has to qualify by one of these other things which I have listed here on the screen. The assassination of the President of the United States. Okay, well, that doesn't happen very often. If you do it for hire, so if you hire somebody to do it, if you are escaping detection for another offense, and I can list all these, but I will tell you, I've bolded the ones that are most likely to fall under a specification here in the state of Ohio or in Summit County. And that is to kill or attempt to kill 2 or more people. And during the commission of one of those other offenses with prior calculation and design. So if you're committing a rape and you plan on killing the person after you rape them, that is typically where we kind of find these type of offenses. It's maybe not rape, but it could be an aggravated robbery, where you kill the clerk after you rob this convenience store, types of that. On occasion, and we have unfortunately recently, the last couple death penalty cases we had involved victims. We actually had both of these things, victims under the age of 13 years old and 2 or more people were killed. So those are the type of egregious offenses we have that qualify for the death penalty. So if we decide that it qualifies for a death sentence, then we go to a trial, right? So we have to have the offense has to meet the legal qualifications of being a premeditated murder, purposeful murder, or one with those other enumerated offenses. And we have to have a death spec that qualifies it. At that point in time, we go through grand jury, and then we have basically the trial portion of it. Now we get to the trial, which you always see on TV. And in that trial, it's different than a normal trial. During that trial, what we'll basically do is we will have you have to qualify the jury to be able to sit on a death penalty case. And the reason we do that is because we have some people that believe that the death sentence should be always imposed if you meet the legal qualifications. Some people believe that the death sentence should never, ever, ever be imposed under any circumstance, no matter how egregious the crime is. And so the law says that basically, in order for somebody to be qualified to sit on a death penalty case, the jurors can't be either of those things. They have to be somebody that is willing to listen to the evidence, follow the law, and weigh the evidence and to make a determination whether the death sentence is appropriate or not. And we'll talk a little bit about what that means. So they can't be either completely for it or completely against it. They have to be able to have an open mind, listen to the evidence, and weigh evidence. After we qualify the jurors, then we have the evidentiary part of the trial, which is where we present the evidence of the case. Here's the DNA, here's the video, here's the eyewitness testimony. And that's what the evidentiary portion is. And then after that, which is different than a normal trial in a death penalty case, we have the mitigation phase. Okay, so we'll talk about these things individually here a little bit more depth. Oops. So the jury selection, basically, and I kind of talked about this already a little bit, but basically the jury selection involves individual voir dire. We don't normally do that. Normally we bring in a group of 30 people. We ask them all as a group questions, and then we pick the jury from those 30 people. In a death penalty case, because it is usually highly charged, with people that have strong beliefs about the death penalty or oppose the death penalty. We have other issues like racial issues that come up, and all those things basically, there are things that people don't want to talk about publicly. So what we do is we take each juror individually and we take them in with the judge and counsel and the defendant, and we go into a room and we basically sit there and we say, okay, here's our questions to you about these things. Is there anything you wouldn't feel comfortable talking about in public that you want to tell us that maybe you're not an appropriate juror for this case? And it could be for many reasons. It could be that they were the victim of a rape, and it's a rape related case. It could be that they maybe have racial biases that maybe they feel like they're not comfortable, and people do, whether you believe it or not, people will tend to tell us sometimes they've had a experience with somebody of a different race and they feel like they couldn't be fair. That's not always the case, but we do have people that feel more comfortable talking about that in a private setting. Once we qualify the jurors that are eligible to do this, and that could take a couple weeks, and basically we'll go through all the jurors until we get we'll go through 150 jurors just to get 50 that are qualified. Once we do that, then we have a general selection process. That's what we call voir dire. That's the jury selection process. We have a general process. In that point, we ask them general questions about their backgrounds, their upbringing, what do they do for a living, do they have kids, that kind of thing. And we talk to them about the general things you talk about every case about their ability to serve as a juror. So then after that, we have the evidentiary presentation. We present our case to the 12 jurors. The defense has now an opportunity to contest all our evidence. They can test or impeach our witnesses, and they can do that throughout our case. They then have an opportunity then to put on their own evidence if they want. As you all know, they have a right to remain silent, and they don't have a burden to present any evidence at all. It's a state's burden. And then after they have their opportunity, we have an opportunity to respond to any of their evidence that they present if they decide to present a case. After that's done, the jury deliberates. At this point, they're just deliberating on whether he did it or not. It's guilty or not guilty. It has nothing to do with the sentence at this point, okay? If at that point in time, there's a verdict, the jury decides that he's not guilty, he did not commit these crimes, he goes home. Case over, right? If they're guilty, and it has to be unanimous, right? So it has to be a unanimous verdict. So if all 12 people believe that he is not guilty, then he goes home. If they find all 12 find that he is guilty of the charges, but not the specification, that's that extra death spec that we put on there, then the court sentences him and the death penalty is off the table. So they have to find him guilty of the crime, the underlying crime, and they have to find him guilty of that death specification. If they find him guilty of both, then you move on to the next phase, which is that mitigation. So you remember we had the jury selection, evidence, and then mitigation. Now we drop to the mitigation portion, which is where we determine whether he gets a death penalty or not, okay? But you have to have both the conviction of the crime and the conviction for the specification. So what's mitigation? Typically, after the verdict for guilt and the specification, there's a short break, maybe a few days, maybe a week, and we keep the same jurors, and those jurors come back, and we basically have a mini trial. And during that mini trial, we present evidence of aggravating circumstances, which is basically the specification. So we would, if the facts were that the specification for death was that the victim was under the age of 13, we would present evidence about the crime and that the victim was under 13. After we present our case, and it's very similar to what they probably already heard during the trial, but we present that again in an abbreviated fashion, the defense then has an opportunity to present mitigation. Mitigation is basically anything that the defense wants to tell the jurors that weighs in favor of a life sentence. It's those things about the defendant, his background, his upbringing that wouldn't necessarily be relevant during the trial, but it's things to talk to the jury about, like, hey, here's why a life sentence is appropriate and you shouldn't put our client to death. Factors that lessen the moral culpability or diminish the appropriateness of death sentence. That's what the case law says, okay? And so that's what the mitigation portion is. It's us presenting the aggravating parts of the case, them presenting the good things, and I say good, but the factors that the defense believe you should know or the jury should know why a death sentence isn't appropriate in the case. After we're done presenting that evidence, the jurors then go back and deliberate again. At this point, they're deliberating about the sentence. And basically what they're deciding is, do the aggravating circumstances of this case outweigh the mitigating factors that the defense presented beyond a reasonable doubt? And as you've heard probably before, you have to determine people were guilty beyond a reasonable doubt, right? So it's the same standard. It's that same highest standard for a death sentence. If they believe that the aggravating circumstances of this case outweigh the mitigating factors, then the death sentence must be imposed. But all 12 jurors must agree that that is the fact. They must all agree that beyond a reasonable doubt, the aggravating circumstances outweigh the mitigating factors. If that is the case, death must be imposed. If it's not unanimous, if it's 11-1, that one juror says, I do not find that the aggravating circumstances outweigh the mitigation in this case, death is off the table. It's over. Okay. So one person could stop a death sentence. And they could basically, then that would require the jurors then to deliberate on the other options, which is life without parole, or life with parole eligibility after 30 years, or life with parole after eligibility after 25 years. And they would have to choose one of those three sentences. Okay. That has to be unanimous too. So that's kind of what they have to do in order to get a verdict. If the jury comes back with a death sentence, it's still not really a death sentence yet, okay? Because there's another safeguard in place. If they are unanimous and they, well, let me go back. If they're not unanimous and they come back with a verdict for a life sentence, then the court has to impose a life sentence. Death's off, it's done. There's no chance for a death sentence. And in keeping in mind, if that happens in any of these places where that juror stops the death sentence, the state has no right of appeal on that. We can't appeal it and then come back and go get a death sentence. That doesn't happen. Once that happens, it's over. There's no potential ever in the future for a death sentence. If the jury returns a verdict for death, then it's still not a death sentence at that point. At that point, the judge must independently review all the evidence that was presented during that mitigation, and they have to review it themselves and make independent findings themselves that the aggravating circumstances outweigh the mitigating factors beyond a reasonable doubt. So you have actually a 13th juror in the judge, and the judge will have to themselves make that same independent finding. If they agree with the jury's decision, then it's a death penalty. Then it becomes a death sentence. If the court finds that the aggravating circumstances don't outweigh the mitigating factors, okay, then it's a life sentence. Death is off the table. Okay, so the judge then does a review of itself, and they make the same determination as the jury. And if they are for death, it's death, and it's imposed. They enact the jury's sentence. If they find otherwise, death sentence is gone. Okay. All right. So that's kind of like I should say, a nutshell. That was 40 minutes of me talking about how you get a death penalty case enacted or imposed. So then the question becomes, we talked about this at the very beginning, how does our office decide? That's the discretionary part that we talked about, that I mentioned, that, you know, even though it's legally qualifies as a death sentence, the prosecutor can use their discretion and not pursue a death sentence. So how do we as an office in Summit County, how does Sherry Bevan Walsh and her office decide whether to pursue a death sentence in a case? Well, I have on here a new procedure. At this point, it's getting a little bit older. I think we changed it in 2017, and we put it in place. So that new procedure we put into place for a couple reasons. The goals, as you can see here, were to avoid unnecessary capital litigation, because as we know, sometimes you get to the end and there's no death sentence and you go, well, why did we even try this? So we want to make sure that we're avoiding just a capital case just because it qualifies, okay? And it saves time and resources. We don't want to waste time and resources if we know the outcome is likely not going to be a death sentence, because then you're just wasting time and money. So how do we ultimately decide these things? So what our procedure is that basically if a homicide occurs and the police agency brings it to us and they say, hey, here's an aggravated murder case, we will take a look at that case like every murder case, and we'll look at it. We have a violent crime unit, which is 5 supervisors that handle all our murder cases, okay? Those 5 prosecutors will review the cases and determine whether it is legally qualifies for a death penalty. Even though it's legally qualified, they will determine whether they think that it should be a capital case. If in their opinion, it should be, they feel for whatever reason that we should pursue a death sentence in this case, then we set it for a panel review with all the VCU prosecutors, all those supervisors, myself, and Sherry Bevan's first assistant. That's the second in charge after Sherry Bevan Walsh. That's the chief counsel. That's Brad Gessner. I believe he's already talked to you guys about what was it Brady, or I can't remember. Anyway, he talked to you guys.
Yeah, it was Brady.
Brad Gessner. So we will then, the 7 of us will get together and we will meet about this and decide whether we think we should pursue it. During this process, we also talk with the victim's family, and we want to see what their position is on the case. We talk to them not only about just everything that's happening, what they expect with the prosecution for the crime against their family member. We talk about all that stuff, but one of the things we bring up is the fact that this qualifies as a death penalty case and whether we should pursue it or not. Sometimes we have victims' families that say, we absolutely do not want a death sentence. We're against it, okay, which weighs heavily for us. If they want to pursue a death sentence, we take that into consideration too. So after we meet, we talk to the family. If a majority of our panel, the 7 of us, believe that it should be prosecuted as a capital or a death sentence case, and the victim's family also believes that we should pursue a death sentence, we then go to Sherry Bevan Walsh, the prosecutor, and we say, here's where we're at. We believe this, the victim's family wants to pursue it. And basically, what do you think about it? If she says no, it ends right there. We just indict it with the aggravated murder with no death specification, and death is not an option. If she says, I agree with you, I think we should pursue a death sentence in this case, then at that point in time, we make an offer to the defense attorneys. Okay, and this is where it changes, in that previously the defense attorneys, we would just then take it to grand jury and present it to grand jury, and if they felt it was met the legal requirements and probable cause, it would become a death penalty case. But at this point, because as I told you before, we have that mitigation, basically we go to them and say, you know what, instead of going through the whole trial process, and then at the end, you tell us all these mitigating factors that we didn't know about your client. And then we go, oh, heck, if we had known that, we might not have indicted the specification. So why not ask you ahead of time? Hey, you can have an opportunity to come in and tell us anything you want about this to persuade us not to get that death spec on there. Here is your opportunity. At that point, we have a meeting, we set it up, we give them carte blanche, anything they want to tell us. During that time, they can tell us anything about their childhood, upbringing, whatever it is, they can do. After that, we review it again, we review what they say, and then as a panel, we reevaluate it, and then we come up with whether we think that we should stop pursuing it or whether we should continue to pursue it. We then go to Sherry, and we basically say, Sherry, we reviewed it, here's what they presented to us, and here's what our opinion is. And you tell us now, based on that, do you still want to pursue the death penalty? And she will give us her answer on that. And if she says, I still think we should pursue it, I don't think the mitigation was very persuasive, we will then go to grand jury and pursue that. If she says, nope, that swayed me, I don't think we should pursue it, it's over. we don't pursue it, it's not a death penalty case. And that's kind of the process that we have in place currently. Things we look for during this process are the strength of the case. Okay. I will tell you that pretty much you will never ever see a death penalty case as long as Sherry Bevan Walsh is in office that is an eyewitness only death penalty case. If you have eyewitness only testimony, it's never going to be a death sentence case. We're going to need some other corroborating evidence like DNA or video or something of that nature. So we want the strength of the case to be pretty much unequivocal. The heinousness of the crime, that's important. How cruel they were to the victim. The vulnerability of the victim, right? If they're young or if they have a disability or something else, you know, that they are vulnerable. Elderly, sometimes, you know, we have Alzheimer's patients, people. The relationship to the party. We've all seen horrible cases of divorces and the spouse, you know, consistently pursues the person and causes them all kinds of anxiety and grief, and then eventually gets to a point and culminates in a death. Senseless killings, you know, they rob somebody and they walk out and they got the money and they turn around and they go, you know what, for no good reason, I'm going to kill you. And they just shoot the person when they've already committed the crime. They could walk away without hurting anybody and they still kill the individual. The senselessness of it, the motivation behind the killing. Is it for money? Is it for hire? Those things. And the level of culpability of the defendant, how blameworthy is the defendant, and any other factors that we think might be appropriate, okay? And I know I'm getting to run out of my time here, so we have time for questions. So to date, we've had 5 cases that we have basically believed should have been pursued since 2017 as a death penalty case. Of those 5 cases, once the mitigation portion was presented to us, 2 of those then went on to be death penalty cases. So of those 5 cases, we initially as a group decided with Sherry thought, okay, we should pursue death. The defense presented mitigation. We changed our mind and basically said, no, we shouldn't pursue it at this point in time. They've swayed us away from pursuing a death penalty case. So basically 40% of the cases we initially thought would be pursued, which in the past would have been had a death specification, ended up not even being pursued for death. And the other result is that the defense bar has pretty much been on board with this. They like it and they want to be involved in this. I will tell you that of one of those 2 cases that did go through to be a death penalty case was a recent one. By the time we got to mitigation, the week before mitigation, we were presented with hundreds, if not thousands of pages of documents that we were not privy to, expert reports and things of that nature that basically gave us all kinds of information about a horrible, abusive situation as a child, sexual abuse, all kinds of abuse that we knew nothing about. And basically, after the case was over, the jury decided against death. And basically, the jury then afterwards, we talked to the jury with defense counsel and they said, you know, they asked us about it. And we said, well, we didn't know about this until a week ago. We gave them the opportunity and they didn't present it to us. That might have stopped a death specification, but we didn't know about it. So we pursued it because it was a child. They asked the defense attorney, why did you withhold this? And they said it was strategy. So there's a situation where the defense could have told us this ahead of time and might have resulted in no death specification, but instead we went through the whole process and to find out at the very end that it was probably something that we had not done a death sentence or spec on similar situations. So as long as the defense bar participates, they have a higher likelihood of not getting a death specification put on their case. So that's just kind of one example. So if we had known that, it might have only been one of those 5 cases that had gone through as a death specification case. Okay. So that's the result. At this point, I think I've got 6 minutes left. for questions, comments, whatever you have. So I'll open it up to you guys. Hopefully it wasn't too confusing. I know it's kind of convoluted and maybe a little complicated in things that you haven't heard before, in terms you might not have heard before, but now is your opportunity to ask me any questions you want.
Brian, we have some questions in the chat. Meredith had written, I feel like I'm going a little backwards. This could be answered at the end. When one receives a pardon, does the crime still show up on their record? Is there a process to get it removed?
Yeah, if there's a pardon, then it's basically forgiving them of that offense. There are certain statutory requirements for sealing that record, but basically the conviction never happens. Whether it's sealed that they ever went through the process is another issue. So if you were, let's for example, if you go to trial on an aggravated murder charge and it's the only offense you've ever had in the past and you are found not guilty, there is a process for having that record sealed so that you can't do a search online in the clerk's office and go, oh, look, this guy was charged and found not guilty of a crime. It's not on your record as far as that goes. So yes, to some degree that happens, but reality, anybody that's tried with an aggravated murder, even though your record's sealed, it's all public because everybody knows about it. In the newspapers, you could do research and find it somewhere other than in public, other than in government records, okay? But yes.
Another question that was asked by Joyce is, please discuss how mental capacity of the defendant affects death penalty cases. And then she also asks, can a defendant waive a jury trial and request a judge only in a death penalty case?
All right, so the mental capacity, we do have laws in place to protect those that are mentally incapable of being put to death. And we call it an Atkins hearing. So there are certain factors, and we could spend an hour talking about it. But basically, if a person has functional disability and combined with an IQ of 70 or below, they're not eligible for a death sentence. And we have hearings and things of that nature to determine that pre-trial to see if they're even eligible. So if you have an individual who has an IQ of 65 and they have to have full-time care, or they can't function on their own, live on their own, take care of their own health needs and things of that nature, they are probably not going to be eligible for a death penalty. As far as mentally, if you're talking about I'm losing my words here. Like if they have a mental disease or defect, that would be more of an insanity defense, and they would have to prove that they didn't know the rightfulness or wrongfulness of their act. And if that's the case, they would be found not guilty by reason of insanity. They would be basically committed like John Hinckley was for shooting Reagan, right? He was committed not for murder, but he was committed because he was not guilty by reason of insanity. And eventually they say, hey, he's able to be released because he has been, not cured is the right word, but he's controlled and he now knows right from wrong. So that's in place. Okay, and did I answer all of that, Tanya?
Yeah, it looks like you did.
Oh, yes, the judge, you
then the
can
jury.
go to jury for a death penalty case, but again, because of the safeguards and the irrevocable nature of it, we don't put it in the hands of one individual. So we have a panel of 3 judges. They have to independently make their own unanimous decision for death. Just like the jury, they would have to determine individually the aggravating circumstances outweigh the mitigating. If any one of them says no, death's off the table. But yes, you can do that. Were there other questions?
Nope, that's all we have in the chat. Does anybody have any questions if they want to unmute?
Okay.
Thank you.
And that means I explained it perfectly and there's no questions. Everybody understands it. And
Yes,
next year you can come back and give this talk to the next group, right? All right. Well, thank you all. Let me just tell you this too. I got 1 minute left. So being the chief of the criminal division, hopefully you guys have no contact with our office, either by, you know, family members being victims or family members being charged or for any reason. But if there's ever a time where you do have contact with us and there's something that you feel is not happening correctly, or you have something you want, it could be good things or bad things. Either way, since I'm in charge of the criminal division, I'm more than happy to talk, take calls, whatever, hear complaints, or if somebody does something good, I'd like to hear that too. So, my door is kind of, always open to the community. I take calls all the time from communities that ask questions about certain things like, hey, I saw in the paper this, why that, why this? I can't go into specific details, but I can talk to you about general things, and answer questions you have. So if you see something in the newspaper and you think that doesn't sound right, you're frustrated by it, you're angry by it, call me, we'll talk about it. We may not always agree, but at least I can give you our side of why we did what we did, or explain maybe sometimes there's misconceptions, and I'll try and clarify those for you. So like I said, my door is always open. Everyone in our office, I know Tanya is always available, and Sherry will take meetings with citizens to talk to them about their concerns too. So please feel free to contact me anytime, okay? Other than that, thank you guys for listening, and enjoy the rest of the Citizens Academy, and hopefully we'll see you out in the community.
Thanks, Brian, for your time. We
Yep.
appreciate it.
Yep.
All right, next up, we have our Assistant Prosecutor, Matt Kuhn, who's going to talk to us about body cams and dash cams. And Matt, we appreciate you being here. And do you want to share your screen, or is James doing that?
I think James is going to.
Okay. All right. I think he's getting started right now.
Perfect.
So if you want to, tell
He's
me
on
about
it.
yourself. Yep. I see it now.
Yes. Thank you so much for having me, Tanya and James. I appreciate you walking me through this and holding my hand so that I don't screw it up too bad. But Brian's a tough act to follow. He's a very sharp guy. Hopefully I'm somewhere close to him. However, I wouldn't count on that. Yes, I was asked to come talk about body cameras, and I'm one of the assistant prosecutors. Obviously, I work for Sherry Bevan Walsh. I'm currently assigned to Judge Croce's courtroom in the Court of Common Pleas in Summit County, and I'm one of two prosecutors assigned to that courtroom. And one of the things that we see, almost on a daily basis, myself and my coworkers, we have to review body cam footage and make sure that we are getting any body cam footage that exists to not only review so that we understand the strength of our case and what evidence is available to us as we pursue criminal prosecutions against defendants charged with felonies, but also we have a duty to turn this evidence over to the defense so that the defense also knows the strength of our case, and they can assess whether or not they need to, come in and plead and resolve their case, or if maybe they think the evidence is lacking and that going to trial is a good idea. But I was, honored to be asked to come speak. This is a pretty neat thing that you folks are participating in. James was telling me a little bit about it earlier today, and just indicated that, these are folks in the community attending this academy who want to know more about this process and who are involved and in tune with, what's going on. And that's very admirable. And so I'm very pleased to be a small part of that. But so the last slide we saw there, we don't have to go back to it, James, but what we were actually looking at is the side of a bus in Akron, and it was a bunch of Akron police officers holding up. Those are actually their body cams that they're holding out there. And I think at one point the police department probably did a little bit of a PR campaign to show off that they were actively engaging in having body cams. I'm sure in the United States, there were some agencies who were reluctant to get on board with using body cams for one reason or another. And we'll talk about some different reasons as we go through the presentation here. But APD, wanted to let the community know that they were embracing it, that they wanted to have video evidence of their interactions with the public, so that they can feel good that, whatever they did is on camera, whether that's good or bad, but they weren't, being sneaky or something like that. So I think that was a wise idea on their part. But yeah, if we could move along through the slide now, James, please. So we're going to go over some of the benefits of body cameras as well as drawbacks of body cameras, and then talk about how local departments and our office utilize that video footage in our day-to-day work. We could go to the next one, please, James. Thank you. So some of the benefits, I think if you go to the next screen, it might populate with some of the information there. Thank you. So there are some studies out now. Body cams have not been around that long. I think they probably, really came on in the last 15 years or so. I've been an attorney since about 2005. And when I got started, there really were no body cams. You would occasionally have cases where there was cruiser camera. That is, obviously, the police cruisers had cameras mounted on the dashboard that showed, pretty much whatever was right in front of the cruiser. And then at some point, that evolved to a situation where there would be the cruiser camera, but then the officer would wear, typically on their chest or something, a microphone. And when they would get out of their cruisers, you could maybe have some audio as well. But unless the action was right in front of the cruiser, you didn't see it. And then, within the last 15 years or so, the body camera has really come about. And, maybe it came on slower because agencies were reluctant to use it. But I think more likely, the technology just was not there yet. The cruiser cameras were sort of crude, sturdily built items that were mounted on the dashboard. They were heavy duty. These body cameras nowadays are very small. I think they're really smaller than a cell phone, and they attach to the officer's chest. And they're also very durable and lightweight. And so the technology just wasn't there until the recent past. And I would say in the last 4 years or so, it's really come on strong where almost every single agency has it now. But obviously we do see some information here on the screen that studies have been done that show that there is a benefit to having these cameras, that it actually makes the criminal justice system more efficient. And what that means is that obviously it says there, evidence from body cameras have increased the number of prosecutions and arrests, but really what I think it does, and my little takeaway from this is that it gives the parties, the state and the defendant, really a quicker understanding of the strength of the evidence against them. If the officer happens to catch somebody red-handed and it's on video, that makes for a much quicker process from arrest to plea to sentencing than maybe if that evidence doesn't exist and it's almost like a he said, she said, or he said type of a situation where the officer's like, yeah, I saw you throw that bag of drugs on the ground, and the defendant says, no, you didn't. Obviously, if there's video cam footage, that speeds things up. That's a big help. James, if you could go to the next one, please. And folks, if you have any questions throughout this process, I will try to keep my eye on the chat feature here. And so by all means, feel free to chime in.
Don't worry about the chat, Matt.
But we do have
for you.
Okay,
And
awesome.
they're usually
Thank you,
asked
Tanya.
questions at the end, so you can get through the presentation.
Okay, that sounds good. So the studies also indicate that the body cameras and the evidence they produce keep police officers honest and accountable to the public. So that's what I was commenting on there a little bit. And that's why the APD would want to have a huge mural on the side of a bus showing them embracing that opportunity. Look, we're not trying to hide things from the public. Here we are. We're going to embrace this tool and essentially do more work by maintaining that system, the body cam system, And we're also going to invest a bunch of time and effort into training, and not only that, but also the financial cost of implementing it, so that we can be accountable to the public, so that we can, openly and honestly interact with the public, and not have maybe this nagging notion that, they're doing something sneaky or nefarious. And so when the police officers have body cameras, the number of citizen complaints and use of force incidents goes down. I have noticed in my job that when defendants realize they are being recorded, and this doesn't apply across the board, I'm sure there's exceptions, but the vast number of defendants, when they see that they're being recorded, they're going to change their behavior. They're going to calm down. They're going to behave slightly differently than if they don't believe that they are being recorded. Okay. And then when citizen complaints do occur, the body camera evidence has been critical to either vindicate the officer or to prove the citizen's complaint, to support the citizen's complaint of what has happened. And so it obviously provides a valuable resource in that regard as well. Go to the next one, please, James. All right. So a buddy of mine named Rick Raley, he's a prosecutor in another county now, but he was with our office previously. I do have to give some credit to him. He came up with this slideshow. He's much more tech savvy than I am, and he's smarter than me too. But he came up with a couple little examples here to help us sort of illustrate these points. And so the first case example he came up with was State versus Annie Oakley. And basically, the little scenario here is that a concerned citizen called the police because she saw someone walking down the street acting weird, and it looked like the person had a gun. If you could scroll through, James. Okay, and then the police report indicates that officers saw an individual walking down the street, and she had a pistol tucked in her waistband with only the butt of the pistol visible. So obviously, everyone knows. I think last month, perhaps, or last week, you folks heard a little presentation about guns and gun violence from my colleague Kevin. But it's something we see every single day. I would feel very comfortable betting my life savings that every single day, every single work day, I deal with a case with guns. And so we get these all the time where some folks have guns legally and some folks have guns illegally. And we have to sort of evaluate the situation to determine, if charges are appropriate, that sort of thing. And so the reason why my buddy Rick included this little scenario in here is because there can be some ambiguity. And so if we go on to the next slide, I think at some point we'll have a photograph here of a couple different folks and how they're choosing to carry their guns. But under Ohio law, the police officer's observations as recorded in the police report would support a felony charge for carrying a concealed weapon. Okay, so that means, the officer goes up and says, hey, you're breaking the law, you're carrying this gun illegally. And the defendant says, oh, no, I wasn't. I'm in the state of Ohio. I'm allowed to open carry my firearm. It's not concealed. I have it in a holster and everything. Okay. And if there was no body cam evidence, if it was just a couple folks on the street, the officer and the defendant on the street or something, it would be a he said situation. But with body cam footage, oftentimes we get a little bit more to that. You scroll to the next one, please, James. Okay, so the first photograph here we get is a gentleman who appears to be filling up his drink cup at a restaurant. And my buddy Rick has indicated here, this is how you openly carry a firearm. And I did see that there was a comment in the chat, or a question in the chat. We'll try to address that at the end. But that fellow there has his pistol secured in a holster, and that's legal to do. That's complying with open carrying. Now one issue that you will run into if you think, oh, okay, the prosecutor just told me I can carry my gun around like that. I don't think you're breaking any law by doing that. However, if you choose to do that at some point, sooner or later, maybe not the first day you do it, maybe not the first week you do it, but at some point, that is going to rub somebody the wrong way. Someone is going to get upset or nervous or scared about it and call the police on you. And then you've got this weird situation that you really weren't signing up for. And so you want to be real careful about, how you carry your firearm. Do you mind going to the next one, James? Okay, then the next photograph we get is another person who has their firearm tucked into the waistband of their pants. And so, somebody might say, well, this is me open carrying it. Well, not really. No, you've got it at least partially concealed under your clothing items. And so, at least recently, that would be likely a concealed weapon violation right there. Can you go to the next one, James? Okay. Additionally, one of the other, I guess I would say benefits, it's kind of a sad benefit, is that these body cams can also capture police misconduct. And one of the examples that we used in this presentation was from 2017 in Baltimore. If you've ever, looked into Baltimore and their crime issues out there, they've got just tons of crime. Unfortunately, it's just a very sort of a depressed area in the city there. And unfortunately, when you get a police agency of that size, okay, when you have just a ton of officers, it makes sense that some of them are not going to be stellar individuals. The vast majority, of course, will be good guys and gals, but you're going to encounter a bad apple or two or three. And in this situation, I guess I'm going to say his name is Richard Pinero of the Baltimore Police Department was basically captured on body cam messing with evidence. And we'll watch the video here. I think it's on the next screen, James, if you don't mind. I don't think it's a very long video, but basically, he indicated that he observed a hand-to-hand drug transaction in an alleyway. He arrested a guy. Then he went back and checked the alley, and here's the drugs, guys. We got them. But if you watch his body cam, it's a little bit different than the way he describes it in his report. Oops.
Of course, the video doesn't want to play for me.
You know what, James, I think we're doing okay on time. We can just probably move on. The bottom line was that this officer, I don't know what possessed him to do this, but he basically went over and very clearly was fabricating. Okay, I'll let it play here. It's, I think, only a minute.
Drugs. Defense attorneys say footage from the cop's body camera shows him placing a bag in this alley before he and two other officers walk onto the street.
I'm gonna check here. Hold on.
The officer goes back to the alley, sifts through some trash, and quote-unquote finds the bag of drugs.
Yo.
The Baltimore Police Commissioner says the officer's been suspended and an investigation is underway.
There's nothing that deteriorates the trust of any community more than thinking for 1 second that uniformed police officers, that police officers in general would plant evidence of crimes on citizens. And that's as serious as it gets.
He adds it is a possibility that the officer was reenacting the discovery of the drugs to get it on camera, and that video alone doesn't tell the entire story. The person arrested in this case is no longer facing charges. For InsideEdition.com, I'm Lisa Wojtycki.
Thanks, James. So what we just saw there, and really that little clip, there's a longer video clip that seems to show the officer clearly already having the drugs in his hand and then being like, oh, look what I just found. as though almost like they had been in his pocket or somehow on his person. And then he's appearing to try to pin it on this suspect that they just encountered on the street. And over the years, I've heard stories like that. I heard horror stories way back in the day of all good, they would stop a guy on a Saturday and take a bag of drugs off of him and say, okay,
I think Matt's signal might be a little.
hey, I'm going to hang on to this for right now. And, can you guys hear me okay?
Yeah, I think Matt, you kind of popped in and out there. I think your signal wasn't, but let's kind of continue. We'll see how it goes.
Okay. Sorry about that.
Oh.
But ultimately, it's not a good look. And on this video here, if this officer was purely fabricating this investigation, that was very stupid of him to do, knowing that he's being videotaped. Now, as you heard the police chief there explaining, it is theoretically possible that he was sort of reenacting the investigation. Maybe he didn't have his camera turned on the first time, and he was essentially reenacting it. But that's just really not a good look. If an officer was to do something like that, it would be very clear on the video, like, hey, I didn't have my camera on. I am now going to walk through the fresh, video segment. And so we see that there, you might think, okay, well, that case got dismissed. Well, yeah, it did. And then 41 other cases did as well, because that officer could no longer be trusted, and it undermined 41 other investigations. And so really these things just have a snowball effect. And I would tell you that the officers that I interact with on a daily basis, I have never gotten a bad vibe from any of them. They're just decent people. They just want to do their job and go home at the end of the day. They want to help the community. I really honestly don't believe I've ever met one where I got the vibe from them that they had some ulterior motive. And so obviously for me, that's a refreshing takeaway. Can we go to the next slide, please?
Now to a dramatic
Okay.
rescue just in the nick
Sometimes
of time.
the video. Go ahead. That's great. Please play it, James.
Police arriving at the scene to find a car in flames, and time was not on their side. A car exploding moments after a dramatic rescue. 2 police officers in Virginia pulling an unconscious woman from that burning car.
Is anybody in there?
Watch as it all unfolded on their police body cameras.
At least one occupant.
The back of the car up in flames, heavy smoke pouring out. Watch as the officer sees the woman trapped, then pulls out his knife to cut her seatbelt. He pulled her out of the car while his partner ran to the passenger side to see if anybody else was inside.
Is there someone in the passenger seat?
The 2 officers, along with some good Samaritans, dragging the driver to safety. That's when, moments later, they heard that explosion. The car then fully engulfed. Officers say it all started from a single car crash. The rescued woman flown to a local hospital with serious injuries. You can really see bravery in operation there. We should say the woman who was rescued is recovering at a local hospital. It's still unclear why she crashed, but police say she may have fallen asleep or had a medical emergency at the wheel.
We're very fortunate to be alive this morning.
Yes, absolutely.
Thank you. I just saw a question in the chat there. It's a good question. Would I really tell you if I encountered an officer I didn't trust? I think I probably would. Maybe I'm full of it or something, but I think that I would. And hopefully I could say, that was back in 2010 and that officer has since been kicked off the force. So who knows? Maybe I'm delusional about that, but I think that I would. And really there is an ethical obligation, not only for myself, to point out things that I see that are bad. But I think even amongst the officers, they have a desire to weed out the bad apples. You know, we've seen time and again recently where bad police behavior, you know, gets a spotlight shined on it, and it makes everybody look bad. And so there is, I would say, a rigorous process to make sure that things are done on the up and up. So obviously we did see the heroic video footage there of the officers dragging, an unconscious person from a burning vehicle. I've seen heroic things on body cam. I've seen some funny body cams. I've seen some crazy body cams. I've seen shootouts that are very scary and dramatic. But more often than not, you see sort of mundane, everyday interactions between officers and people in the general public. And more often than not, it's decent interaction. It's not nasty. It's not the officers calling people names or people calling the officers names. It's usually a very low key kind of a thing, almost businesslike and polite. And I think the officers understand that you really get a better response if you're not aggressive, if you're not sort of amping up the situation. I think if you are respectful and, just let the folks know that you're doing your job, I think that goes a lot further than if it's sort of a hostile kind of an interaction right from the get-go. And one of the things, we saw the very dramatic, heroic rescue there from the fire, but oftentimes you'll see less dramatic, but still very decent and heroic actions where officers are assisting oftentimes children from a crime scene, and they're showing compassion and decency. And so it's kind of a nice thing. In my line of work, you can get very burned out when you see just crime and nastiness 24/7. You have to really look for these wholesome and endearing types of things on the body cams, and you'll find them if you look. The next little thing we have here are the drawbacks of body cameras. James, if you don't mind going to the next screen. I think there's another video coming up that I think we'll probably skip it, but what the video is there for is to demonstrate that these body cams are not perfect. Unfortunately, the body cams don't show everything. The cameras are, at least in my experience, they've always been physically located on the officer's chest. And so, you might think, if you didn't know any better, that it would be like up on their head or something. And so that if the officer looks around, the camera is essentially looking around. And early on, there were some body cameras that were like that. They attached to the officers either eyeglasses or sunglasses. And I worked in a different county previously, and the police there had ones that were attached to their glasses. And so that was kind of a neat experiment. But I think it was determined that just was really not the most feasible way to collect body cam footage, because it was too easy for them to be knocked off or knocked out of line. They were a little bit more fragile. The ones now are a little bit more hardy. Like I say, they attach to the officer's chest. I have seen them pop off if they're fighting with someone, but for the most part, the camera stays put. The officer typically activates the camera by pushing a button on it. And I think the officers are directed to have the body cam running anytime they're interacting with someone in the public. And so that's, again, really to protect them and protect, the public that they're interacting with. James, do you mind going to, there we go. So the next scenario is that the police receive a 911 call from multiple citizens indicating that there's a guy walking down the street with a gun. The police even show up and they see him walking down the road with a gun. Now, by the time they can, essentially catch up to him and meet up with him, the gun is gone. And I forget if this was a Stowe case or something, but do you mind going to the next screen, James? But the bottom line, there's kind of a lengthy vehicle, or I'm sorry, a lengthy video. And we could watch it, but it's like 5 minutes long, and it just doesn't show anything. It's the officers driving to the scene of, the alleged crime, and they get there and they see the guy with the gun, but that's not captured on the camera because the officer is driving a car, and the camera is basically, it's believed that he threw it sort of over an embankment into a wooded area, and the gun was never found. And so, I think the reason why that video was included in this discussion is just to demonstrate that, even with the best technology and with best efforts, I mean, the officers were on the scene in such a timely fashion that they find the guy, but it just doesn't capture the action. It doesn't show him throwing the gun anywhere. And so they're just not perfect. And that's what we run into all the time in our cases that we prosecute, is that we think, oh boy, we've got 12 different officers who eventually made it to the crime scene. Surely some of this body cam footage will be of value, will be helpful to the case. And oftentimes it is, but not always. It's just not perfect. Do you mind going to the next screen, James? Okay. So another drawback, in addition to it not being perfect, is that since 2014, we can see here that, the city of Los Angeles Police Department has recorded 2.1 million hours of body cam footage. I would wager that Akron has not recorded that much, but it is still a ton of video footage. And so not only is that footage overwhelming for myself and my colleagues to review for every single case, but typically you have to retain that footage for a period of time, at least while the case is active, and then more likely for the pendency of any sort of appeals. And as I think probably most people now know, you have to pay to store that information. There's no free data storage place. It's costing the taxpayers money. And so I'm sure there's a way to do that in a financially responsible way, but it's still just a ton of money. And so if you went back 15 years ago, that's not even a thing. And now it's this huge financial obligation, and it's got to keep going. It's got to keep going forever. And so, it seems like it's here to stay. Do you mind going to the next screen, please? Okay, as I just said, it costs a lot. The implementation of body cams was a huge, just a seismic shift to where, agencies, like I say, maybe way back in the day, they had 0 cameras, then they got cruiser cameras, then they had to invest in these body cams. And then maybe they did a little trial and error process and figured out that the cameras that they initially invested in were not the best, and they've got to switch. And so there's a lot of trial and error here. It's very expensive. We see that an average camera is $1,000. I mentioned that they are about the size of a cell phone. They're probably about the same as a cell phone in terms of the technology. They're a little computer that turns on and off at the push of a button to record very important information. And so that is a huge barrier. And that prevents smaller agencies in particular from being able to afford it. Do you mind going to the next one, James, please? Okay, local departments and SCPO policies. So Akron obviously has the body cams. I think they were one of the first to get on the scene for that. Even our smallest department, Reminderville, has gotten on board. And so we've got everybody with body cameras. We obtain all that footage. As I said, we have an ethical duty to review it as best we can, but also to turn it over to the defense so that they can have all of the evidence available for their case to evaluate its strength or weakness, and to see if there's, maybe some information on there that's helpful to them. There are exceptions to that. Certain like undercover units, I think, don't have to have that for privacy reasons, including things like keeping confidential informants secret, that sort of thing. But for the most part, they do have to. APD started in 2017, 215 officers have those. So that's $215,000 right there, right off the rip for the cameras themselves. That does not include the data backup storage. And so we get a lot of footage. You know, they're supposed to be activated during citizen contacts. Go to the next one, please. I'm sorry, folks, I'm trying to get through this in a timely fashion. I'm sure everyone loves hearing me speak, as my family does, but I do want to get you out of here in a timely fashion. So in an effort to be an effective advocate for our community, you know, I have to feel like I'm reviewing body cam in an appropriate fashion. What that means is that if I'm reviewing it and I see something that's wrong, I see the officers misbehaving or something that would exonerate the defendant, I have an ethical duty at that point to tell the defense attorney, hey, look, you know, I just checked out the body cam and we got the wrong guy, or whatever the case might be. And it typically doesn't play out that way, but you know, mistakes do get made. We're all human. And so there have been some, you know, some instances where the body cam helped to exonerate a defendant. And so obviously within my office, we would report any misconduct that we would see. There's my contact info. James just had it up there. And you know, I am very pleased that I was allowed to come here and meet with you all. And I do appreciate your time.
Thank you, Matt, so much for your presentation. We do have some questions. One of them is, what would be the reason and when would it be okay for an officer to turn off their camera and after a period of time, then turn it back on? And that's from Joyce.
Okay, so one thing that we see very, very frequently is where officers they'll stop somebody, either a traffic stop, or they'll be responding to a crime scene or an alleged crime scene, and they'll meet with a citizen for a period of time, and then at a certain point they walk away and they might not turn their camera off, but they'll turn their audio off. That's something we see all the time. And what the deal is there, when officers speak with one another, they do not have to keep that audio on. And the reason being that it's, you know, they're having essentially a work conversation that is not an interaction with the public. They're determining how to handle a situation. They might be calling their supervisor to get direction on what to do. And so that information is allowed to be kept off the record. And so they turn their audio off. When they return to speaking with a citizen, they are supposed to turn it back on. My hunch is that maybe a mistake happens here or there where they forget to hit the button to turn the audio back on. But for the most part, when they are interacting with the public, they will hit the button on their camera, and the camera will actually go back in time. It's usually 30 seconds and pick up recording from then on. And so that information is supposed to be captured on the body cam.
And Matt, I know we were talking about this before. One of the interesting things about most of the body cams is that it does record that 30 seconds, but it doesn't have audio for that 30 seconds.
That's true. That's true.
That's one thing also I think that maybe not a lot of people realize, that the officer will start recording, but there won't be any audio for the first 30 seconds. In that video where we're going to show an example, which is kind of long, you would have seen the officer moving around and you wouldn't have heard anything for 30 seconds. And that's just one of the things that the body cams have.
Right. You know, I think there was maybe a question in the chat about, you know, who has the body cam technology, who are these companies?
Who does Akron contract with to sell the body cams and hold the technology?
Well, I think I believe it's a company called Axon, AXON, They seem to be the primary facilitator of the body cam technology. It looks like the agencies that we use primarily go through there. And so they run a thing called evidence.com. And so part of my job is every file I get, I have to look through the case file and see what evidence is contained in there and what police reports are in there. But I also have to determine if there are things like body camera and cruiser camera videos and where to find them. In the what I'll call the olden days, the different agencies would give me a DVD that might have 2 minutes or 8 hours of video footage on it from cruiser cameras and sometimes body cameras. Now, the more high-tech way of doing it is that they load it onto a website called evidence.com. And I have an account on there. And so I can get on and I can look at what cases are assigned to me. We initially looked them up by police report number, and I can see, oh, okay, there were 8 officers on scene, and I can watch their body cam footage. But I guess I would say the real convenience part of it is that through that website, evidence.com, I can send access to the defense attorney. And when I send them access, they get an email telling them, hey, Matt Kuhn has just sent you evidence.com materials for such and such case. Get on there and look at it. And so it's sort of revolutionized the way we do it, where we don't have to copy DVDs and that sort of thing. And really way back in the day, we would copy VHS tapes. I was around for those days too. And so this is obviously a much more high-tech version of the same thing.
Okay, it doesn't look like we have any more chats or questions in the chat. Does anybody have any questions they'd like to ask? Just they can unmute.
I thought Ohio was now an open concealed state.
You know, I don't feel comfortable giving what I would call legal advice on the open carry thing. It's a very new change in the law, and it has changed to allow more opportunities to carry concealed weapons, and it's affected the way that we prosecute cases. A great number of cases that we get have to do with folks who were not transporting firearms in what was previously deemed a lawful manner. Now it's a little bit changed recently. And so I do believe that you can carry a concealed weapon without technically obtaining a CCW license from the state of Ohio. But I just don't feel comfortable giving advice. You know, I would encourage you to look into that personally if you think that's something you want to do.
Right. No, I was just asking because I have talked with several Akron police officers who have stated that, in fact, you can now carry the same way they would. So, I mean, if you get in a car and drive, as long as you're not, obviously, there's other circumstances that would keep you from having a firearm under the influence, etc.
Yeah,
But
there
as far
are.
as if you're just a regular law-abiding citizen, no alcohol, no drugs in effect, that in fact you can carry a concealed weapon the same way an officer could. You don't have to have them in separate parts of your car any longer either. I just was wondering the way when you were talking, and that's why I asked the question. I just wanted to clarify because you were saying about the concealed or the open carry, but now that we're an open concealed, state, I just was wondering.
I think the purpose of the video was not to go into the gun laws, which we did last week, but it was more to show you, okay, look, body cam footage can show you if someone is carrying, if they're not, and what that looks like with the body cam footage when you're looking at the comparison. So you don't have the officer's word against the person who's carrying's word. If the person, says one or the other, I don't think it was intended to bring about, all the changes that we've had in terms of our open carrying and
fair enough. Like I said, when he said
no,
that
so
open
he's
carry,
he was just showing it. Yeah, no, he was just showing it as an example with open carry or closed
okay,
carry.
no problem. Thank you.
No problem. All right, any other questions? Somebody just said, I've heard it said science has detrimental visual evidence is the weakest evidence. Any thoughts on that?
I guess I'm not exactly understanding.
I mean, yeah, I'm trying to look at it too. Science has detrimental visual evidence is the weakest evidence.
Maybe just the idea that sometimes our eyes can't.
I meant to say determined.
I'm sorry, Mr. Burns?
I meant to say determined that visual evidence is the weakest evidence.
Well, yeah.
In other words, shouldn't you have more evidence other than just visual?
Yeah, obviously we want to make sure that we collect any type of evidence that we can to support our case and to strengthen it appropriately, obviously. And so video evidence is just one piece of that. In fact, I very recently had a case where I believe it was the defendant was videotaped committing a burglary. Now, unfortunately, I think primarily due to COVID and maybe due to the defendant trying to conceal her identity, she had on a mask. And so you could not see her face. And so the video was crystal clear, but because she was covering up her face, it didn't add a whole heck of a lot to the strength of our case. It was one more piece of the puzzle, but you're right. Visual evidence is not perfect, and it's, you've got to keep going. You have to keep investigating and try to find other evidence as well.
So, Mr. Kuhn, I have a question.
Sure.
The concern is always, what do police officers, first responders, what do they do to kind of process all that they see every day, the violence, the murders, the horrific crime scenes and so forth. So people like yourself that deal with this on the other side of it, what do you do to process through all of this and not take it home?
Right. And I'm sorry, my computer is sort of freezing, but no, that's a great point. I don't think I'm quite in the know. I would hope that there are some sort of policies in place for them to get counseling if they need it. You're right. That is a main concern, that these officers do need some sort of way to channel this information and to process it so that they don't get a kind of a warped worldview and then lash out at some point.
Mr. Kuhn, I'm sorry, because you froze, maybe you didn't hear all of my question. I was saying, what do? You and people like yourself that work on the other side of it, what do you do to, keep your mental state safety? I guess safe is what I'm asking.
Right. Okay, you're right. I'm sorry, I did miss that. It's a tough, it's kind of a tough business. And so one thing that my coworkers and I try to do, we try to have a little bit of fun, and we have to make sure that when we do that, it doesn't appear as though we're not taking this seriously. And so we do joke around, and sometimes we'll give each other a hard time in sort of a playful way, but we have to be very aware that we have victims and witnesses coming in and out of our office all the time. And so if they hear me and my buddies kind of joking around, they might get the impression that, that we're not taking this seriously, or that, we don't care about their heartbreaking victimization. And so we do try to have a little bit of fun. That's a big part of it.
We do our office, sorry to interrupt, but we have done some trauma informed care, like some seminars. We've had somebody come in and talk to our prosecutors about, the things that they are seeing. And so it's a good question, because I don't think there's enough being done, just like Matt said, even with our officers, I'm guessing, and I don't know all the programs that they have, but the officers probably are not doing enough, and we're probably not doing enough, but we are aware of it. We have had people come in and talk about the trauma-informed care and talk to our prosecutors in small groups, about the things that they're seeing and they're talking about. We also have Avery, who, is wonderful because he's there for our victims, but he's also there, you know, to help us, you know, when we have really hard days and we're looking at cases that are, you know, horrible, you know, Avery's there kind of to soften whatever it is that we're seeing at the moment. So and you know, we do try to do different things in our office in terms of like, you know, in services where we do trainings, but we give time for a little bit of lunch before so that everyone can be together and kind of vent. But I think along the lines of what Matt was saying is oftentimes the relief, you know, that people find and the way that they cope is by talking to each other. And there's a good camaraderie in our office with everybody, you know, venting to each other and talking to each other about cases and kind of getting it out. Sorry to interrupt, Matt. I was just trying
No,
to.
that's great.
Yeah.
That's great. Thank you.
Any other questions for Matt? All right, great. Well, thanks for staying a little later, everybody. Matt, thanks so much for your presentation. There was some comments in the chat saying thank you. And we appreciate your time and you being here, you and Brian. So thanks so much.
Thank you all so much. Take
Thank
care.
you.
Have a great night, everybody.
Bye. Thanks.